Hey folks, this is immigration attorney Hassan Abdullah, and I'm preparing this video to provide an update on USCIS's policy towards the Deferred Action for Childhood Arrival Program, DACA. And so DHS is begins limited implementation of DACA under the final rule. So on Monday, October 31st, Halloween, the Department of Homeland Security has a final rule to preserve and fortify deferred action for childhood arrivals. It went in effect on that date. The final rule's implementation is now based on formal regulations. It's not like a presidential declaration or a declaratory order. This is actually formal regulation. And so thereby fortifying and preserving the program while the program remains the subject of litigation in court. Previously, DACA was based on policy memo, as I mentioned, and it was issued, August 15, 2012. It's really been a while now. Since its inception, 800,000 people have benefited from DACA. But here's the thing, as good as this sounds, that this is now formal policy, a final rule, that is, a formal rule, the issue here is that because there's still a court order, according to USCIS Director M. Jadu, while court orders prevent us from adjudicating requests from initial applicants, we will continue to carry out the important work of renewing and continuing protections for current DACA recipients as outlined in the final rule. So you can still file your application. It's just if it's a new application, it's still going to be suspended due to this litigation. Another thing is this, just to kind of go over something very important related to DACA, is if you're looking to get a green card and you came here illegally but you have DACA, you can find a way to leave the country and come back, and that will be considered not a departure to trigger immigration bars, yet it's considered on your return from that trip to be a proper lawful admission. And if you are lawfully admitted to the US, you're eligible to adjust status. So again, that's a very useful feature for those who have DACA, which is they leave the country on advance parole. They get the advance parole based on perhaps doing a study abroad program. There's a lot of these programs for Mexicans in particular, where they can study abroad to go overseas, and they're like exchange. They're cultural heritage programs. Basically, you just go back and you do some studying, and you enroll in the program. If you look it up online, you'll probably be able to find quite a few opportunities like that. Another thing is if you have a sick relative, or if you have a business-specific reason for training. Let's just say you need to do training in another country, or maybe there's a conference or convention overseas that you need to go to that's going to benefit you in your career, and your employer can write a letter supporting that. We've also gotten DACA advanced parole approved on that, based on that as well. So it's definitely a great thing, because you can then, if you have a spouse who's a US citizen, you can now adjust your status without problems and without relying on a higher an I-601 hardship waiver. So basically, I just wanted to go over this. It's a step in the right direction with DACA. Hopefully this becomes, the court does not prevail. I mean, the case doesn't prevail in court that is against DACA, and we have a meaningful path towards green card and citizenship for those who have been waiting so long. Thanks for watching, and we'll see you in the next video.